So in this lesson, we're going to take a look at liability in tort. There are two basic types of liability. There is primary liability and vicarious liability. So primary liability arises due to one's own personal wrongdoing, so it's our own behavior. Vicarious liability arises when there's a relationship that someone has to the person who actually commits the tort. So an example of this would be an employer. An employer is liable for the torts committed by their employees acting in what the court refers to as the ordinary course or scope of employment. We're going to explore this just a little bit more. So we know that employers can be liable for the torts committed by their employees. However, it only happens under certain circumstances, and the law stipulates that the employee must be acting in, quote, the ordinary course or scope of employment, end quote. So what does this actually mean? Well, that too is defined by the courts. The court says that it is within the scope of employment if 1, it is authorized by the employer, or 2, it is an unauthorized mode of doing something that is in fact authorized by the employer. So let me give you an example. Todd is an employee at Carol's Donut Shop. If he is twirling a tray full of hot donuts that just came out of the fryer in the air and drops them on a customer, do you think this would be considered within the ordinary scope of employment? So we look at the first element, and is it authorized by the employer? Well, twirling a hot tray of donuts is probably not authorized by the employer, so that doesn't apply. Then we look at the second element. Is it an unauthorized mode of doing something that is in fact authorized by the employer? In this case, it could be argued that it's an unauthorized mode of doing something, but it is something that is authorized by the employer. So Carol authorized Todd to move the donuts. It was part of his job. So we could say it's an unauthorized way of moving the donuts, which was part of his job. Because of this, Carol could be vicariously liable for Todd's actions. Tort victims themselves can be partially responsible for their own injuries. We call this contributory negligence. It's a defense that can actually be used by the defendant when arguing that the plaintiff is at least partially responsible for the harm that has occurred. If it's successful, the damages, or money, will be reduced by the amount for which the plaintiff is responsible. This is a common defense in car accidents. For example, a lawyer may establish that some of the injuries were due to the fact that the driver was not wearing a seatbelt at the time of the accident. In that case, the victim would be said to be contributory negligent. So here's another example. The bicycle rider was not wearing a helmet at the time of the accident, causing injuries to be worse than they otherwise would have been. So if this bicycle rider were hit by a motorist, maybe they were negligent, the fact that the bicycle rider was not wearing a helmet and therefore the injuries were worse would indicate that they were contributory negligent. And the court would reduce the plaintiff's award by his or her percentage of the fault. So let's say they had been awarded $100,000. It was argued that they were contributory negligent, and the court says, yes, 40% was due to the fact that you weren't wearing a helmet, then the damages would be reduced to $60,000. So now let's look at an example of contributory negligence. Take a moment to read through this mini case. So the question here is the employer responsible to Archie for negligence? Would a court find Archie to be contributorily negligent? There are special responsibilities that arise in the employer-employee relationship. Employers are responsible for keeping their employees safe, even in unusual circumstances like a holiday party. Even though Archie's employer took some steps to protect him by offering to drive him home, the courts would see this as insufficient. There is a similar case to this scenario. It's Hunt versus Sutton Group Incentive. And in this case, the defendant, Sutton, was the employer. And the courts held that they owed their employee an obligation to take reasonable care to avoid acts or omissions that could reasonably have foreseen would likely cause her some harm. And it also owed its employee an overriding managerial responsibility to safeguard her from an unreasonable risk of personal injury while on duty. The court argued in a similar case that it was open to them, the employer, to send the plaintiff home by taxi, if necessary to take her car keys away and to take custody of her car. Alternatively, it should have taken steps to call her common-law husband to come and pick her up. Alternatively, he could have taken her to a local hotel or found somebody else who had not been drinking to do so or to drive her home. Given the similarities between our scenario and the case, Archie will likely be found to be contributorily negligent. In the similar case in Sutton, the judge said, "I find that her consumption of alcohol was self-induced, just as I have found that her degree of impairment due to the consumption of alcohol was a cause of the accident, so too is her self-indulgence in partaking of such alcoholic beverages an attributable cause to this accident." So in this case, as there was in the Sutton case, there will likely be a finding that the employer was negligent because they didn't stop Archie from driving, and it'll likely be found that Archie was contributorily negligent, and his damages will be reduced by the percentage allocated to him by the court. So the primary goal of damages in tort law is to compensate the victim for loss caused by the defendant. It's usually a monetary judgment, but it can also be others such as an injunction. And if you remember, an injunction is an order to stop doing something. In tort law, the plaintiff is entitled to be put into the position they were in before the tort was committed. Tort law compensates for physical injury, loss, mental pain and suffering, and emotional distress. I want to bring this to your attention again. We talked about it before. Tort law is primarily common law, but it's been modified by statute law. So remember we talked about the sources of law and how common law is judge-made law. It relies on the notion of precedence. But then we have legislation or statute law. And in the case of workers' compensation, we see where statute law actually modifies the common law. Workers' compensation legislation provides monetary compensation for work-related injuries and illnesses. So if somebody gets harmed at work, they will be compensated through workers' compensation legislation, but the statute takes away an employee's common law right to sue the employer. So it's a little bit controversial. People wonder, should employees be deprived of their right to sue their employer when that employer has been in the wrong and caused the employee's injury? It's an interesting debate. Now we'll look at the different types of damages. So when a person is injured by the tort of another, their damages are categorized as either being pecuniary or non-pecuniary. So pecuniary means monetary, and pecuniary damages fall into three main categories. They are the cost of future care, the loss of future income, and special damages, otherwise known as the out-of-pocket expenses. So they're calculated through evidence of actual out-of-pocket expenses. So perhaps you had to pay for an ambulance or build a wheelchair ramp into your home, that kind of thing. Expert testimony of future financial losses, such as those which arise because of the loss of future income, as well as expert testimony as to what it would cost to care for the plaintiff in the future given the injury sustained at the hands of the defendant. Non-pecuniary damages are compensation for pain and suffering, loss of enjoyment of life, and loss of life expectancy, again caused by the injury sustained at the hands of the defendant. Punitive damages are an exception to the general rule that damages in tort are intended only to compensate the plaintiff. So punitive damages are more rare. They are awarded to punish the defendant for outrageous, antisocial, or illegal behavior. It's often referred to by the courts as malicious, oppressive, and high-handed behavior that offends the court's sense of decency. For example, if someone gets behind the wheel after drinking alcohol and then intentionally drives their car into the path of an oncoming car, causing injury to the driver, punitive damages may be awarded. Then we have something called aggravated damages. These are damages that compensate the plaintiff for intangible injuries such as distress and humiliation. Again, they seek to compensate the plaintiff, not to punish the defendant. But they're used when the behavior of the defendant is outrageous and malicious and causes distress and humiliation. An example would be a security guard who humiliates and degrades a person who they are illegally holding, maybe false imprisonment. This person, because of the humiliating and degrading way, may also cause awards for aggravated damages to the plaintiff. I'll use a mini case to illustrate some of the concepts we've just covered, so just take a few minutes, pause the video, and read through the mini case. Okay, so we are assuming that Jason can prove that the tort of battery took place. The question here is, do you think the court will award Jason aggravated damages given the circumstances? And then what about punitive damages? So this case actually is based on a real live case called Merrick versus Guibo, 2009. And the judge in that case stated, "I have reviewed the evidence and as noted above, I have found that this attack was mindless, unprovoked, and resulted in emotional distress and humiliation to the plaintiff. The plaintiff did not want to show his parents his weakness, and he felt that by doing so that he had let them and his friends down. While giving evidence, he required time to regain his composure when he thought of the attack and the resulting helplessness that he felt. Over the following years, his parents and girlfriends witnessed his struggles with his emotional and physical afflictions. The viciousness and suddenness of the attack, the clear malice of the attack, and the humiliation the plaintiff felt and still feels call for an award of aggravated damages. I am increasing the award of damages from $45,000 to $52,000 to take into account the nature and the brutality of the attack." This case was similar, and it is likely that Jason would be awarded aggravated damages given the circumstances of the attack. Now we consider punitive damages. Interestingly, in the case that we have been talking about, the court could have awarded punitive damages, but they didn't award such damages or explain why not. It's thought that maybe the court concluded that the damages point was adequately addressed through the award of aggravated damages. If we look to a different case, this one is the Supreme Court of Canada in Hill versus Church of Scientology. And here the court held that punitive damages may be awarded in situations where the defendant's misconduct is so malicious, oppressive, and high-handed that offends the court's sense of decency. Punitive damages bear no relation to what the plaintiff should receive by way of compensation. Their aim is not to compensate the plaintiff, but rather to punish the defendant. Knowing this, it is likely that Jason would be awarded punitive damages as well. Again, it would be up to circumstances and the court to decide. So now we're going to look at the notion of proportionality. Basically, the award must be in proportion to the conduct. And I remember when I was in law school, my professor saying you would not crack a walnut with a sledgehammer. And that was the example that she used to explain proportionality. So just remember, the proper award has to be proportionate to the conduct. And in setting the quantum, the amount, the court will look at a couple of different variables. These include whether the defendant's conduct was planned and deliberate. The defendant's intent and motives will also be examined. Whether the defendant persisted in the outrageous conduct over an extended period of time. And finally, whether the defendant conceded or attempted to cover up the misconduct. Sometimes there'll be overlapping liability in contract and tort. So, for an example, when a professional, such as an accountant, lawyer, or banker, gives advice to a client and that advice is incompetent, the professional is in breach of contract and has also committed the tort of negligence. Another example would be a bouncer who punches the patron because they mistakenly believe the patron is about to start a fight. The bouncer's tortious conduct is attributed to his employer by way of vicarious liability that we discussed earlier. It also, though, places the nightclub in breach of contract with the patron, because undoubtedly there would be an implied term of the contract that the nightclub would provide a reasonably safe environment. So just another example of where there is action at tort as well as a breach of contract. No business can eliminate all risk, but ignoring risk can result in lawyers' fees, an amount of judgment awarded to the successful plaintiff, losing insurance coverage, losing a hard-earned business reputation. So again, in this course, we're looking at not turning you into a lawyer, but teaching you how to mitigate legal risk in organizations. So that's it for Module 3, Lesson 1. I'll see you at Lesson 2. As always, if you have questions or concerns, send me an email. I'm happy to answer them. Bye for now.